we've done so far.
Scott Wilk is file item number
Assemblymember Wilk, we would love to have you come up and present a bill with which I have a little familiarity.
Would you like to present it on my behalf?
Oh, absolutely not. It's file item 9, AB525 by Assemblymember Holden and Wilk. This is the Franchise Relations Bill.
I believe it's also Dodd and Atkins.
All right, yes, that is correct.
Just
But,
thought I'd throw that out there.
You drew the lucky straw. All right.
The short straw, Madam Chair.
The file item number 9, AB525. Good afternoon.
Good afternoon, Madam Chair and committee members. I'm presenting AB525 on behalf of my fellow joint authors to modify and modernize the California Franchise Relations Act. I'd like to start by accepting the committee suggested amendments on page 17 of the committee analysis. As you are all aware by this point, there have been many discussions regarding amendments settled on between our sponsor, the Coalition of Franchisee Associations, and the International Franchise Association. Of course, as part of this general agreement, it is pending review and approval by the joint authors, chair, and committee members. I want to be sure my colleagues, in particular Assemblymember Holden, who is unable to attend today's hearing, have the ability to sign off on those amendments before it goes into print. Anybody who's worked in and or around the franchise industry can tell you that the one-sided nature of the franchise relationship quickly becomes apparent after a franchise agreement is signed. This bill does not completely balance the scales, but it does present franchisees from losing their business for ticky-tack violations that should not lead to termination, but sometimes do. Specifically, the bill changes the standard for which a franchisee can be terminated from good cause to substantial compliance. Good cause is a legal standard rarely used in contract law, and even if the franchisor is in the wrong, the ambiguity in good cause can result in the franchisees being terminated. Meanwhile, substantial compliance is deeply rooted in common law contracting principles and is modeled after termination standards that have been successfully used in 5 other states since the 1970s. AB 525 enables franchisees to sell their businesses to a qualified new owner as long as the franchisor approves. The bill also expands what a franchisee is entitled to upon termination or non-renewal from inventory to all tangible goods, a standard borrowed, then narrowed from existing law from the state of Washington. Last year, Madam Chair's bill that nobly fought to protect franchisees made it all the way to the governor. Unfortunately, he had concerns about certain terms in the bill, and which led to the veto. This bill picks up that fight, but is crafted specifically tailored to those concerns that the governor expressed. From the beginning, we worked to address the opposition's concerns from last year and have taken amendments to address their new concerns this year. In fact, their 2 greatest concerns about AB 525, which was contract renewal and monetization of equity, have been taken out of the bill. The decision to amend the bill was not made by the authors alone. It was made in consultation with franchisees who take quick breaks from running their small businesses to advise on the bill, and they believe this will benefit future franchisees. They are not demanding everything, but they do need something. This bill is modeled after effective laws in other states, responds to concerns of the governor and the opposition, and most importantly, protects these small business owners. With that, I respectfully ask for an aye vote, and I do have a number of individuals who would love to testify.
We will allow 2 people, 2 minutes each, and then the third and subsequent witnesses, just their name, affiliation, and support. We've got a long calendar today, and we're not moving very quickly. So 2 people, 2 minutes each, please.
Thank you, Madam Chair. So we'll start off with Keith Miller, Chair of CFA.
Chairwoman Jackson.
Good afternoon.
Good afternoon, Vice Chair Morlack and members of the committee. Thank you for your time. My name is Keith Miller. I'm a Subway franchise owner in Auburn and Grass Valley. I'm also chairman of the Coalition of Franchisee Associations, which is the largest franchisee-only organization in the country. We only represent franchise owners, and our directors are put on the CFA board by their fellow franchisees. And Senator Jackson, I, of course, would like to first start this hearing off by recognizing you. On behalf of franchisees, I want to thank you for your leadership and your hard work during the previous session, moving SB 610 all the way to the governor's desk and bringing more awareness of the issues facing franchisees. We'll never forget your efforts as we continue our quest on this.
I appreciate that because the gray hair is due to that. So,
Look at me. This isn't from making sandwiches all day, you know. What AB 525 is really about is protecting franchise owners in this state first, the people who have invested and create the employment in this state. We are trying to make sure that franchisees have basic rights when it comes to termination. We don't want the franchise company to be the prosecutor, judge, jury, and executioner. While technical terminations are rare, forced sales, transfers, or settlements are often the result, costing franchisees much of their investment. Look, as a franchisee, I'm the last person who wants a bad actor in my brand. However, that does not mean that terminations or actions should be easy. These people have rights, and their assets are their assets. When you look at some of the protections in this bill on the purchase, upon terminations, whether it's a lawful or unlawful termination for the assets in that business, the equipment, and the supplies, it's really kind of about property rights. The franchisee, even if they're bad, do own those. They own their own business. Lastly, and I'm going to shorten this up because obviously we have an agreement and you have a tight calendar. We've all heard about the compromise that got announced yesterday between the CFA and the primary opposition to the bill, the IFA. It's true we have agreed to the compromise amendments that will in turn have the IFA withdrawing its opposition, and those amendments have been sent to the author's office for consideration. We've all worked long and hard over the last few years, and while neither side is completely happy, I believe we have found a good balance to move forward with. It's really a wow moment, isn't it? Senator Jackson, Senator Wykowski is tired of hearing the sandwich maker come testify in front of him for how many years now? I think we're already there. I ask for your aye vote.
And
Thank you very much.
Next, and in 90 seconds, we have Mr. Edward Novelis, who's a former franchisee, who wants to share some testimony.
thank you.
Thank you. Good afternoon, everyone. Anybody okay?
Yeah, you're on. It's on. No, it's not now.
Is that right?
There
There it is.
They'll turn it.
My name's Edward Novalis, and I wanted to share my experience with you regarding my years as an owner of a franchise small business. I have an MBA and extensive business experience, especially in the field of healthcare. In 2008, I left a career in corporate America to start my own small business, hoping to avoid some of the pitfalls of starting from scratch and to find the support and infrastructure that's available in a good franchise relationship. I chose to build a business with a relatively new franchise system called Bright Star Healthcare, which provides home healthcare to seniors, children, and others in need. I was number 45 of a system that now encompasses over 300 across the United States. It was growing, and I was promised both support and flexibility. I quickly discovered, though, that I would receive neither. Instead, what I found was inadequate support, unrealistic and predatory minimum sales targets, and costly vendor requirements. By 2010, I had begun organizing fellow franchisees into an association, and at that point, the relationship soured. I was repeatedly targeted with both internal and external audits, and ultimately, my franchise agreements were terminated. It's hard to believe for someone who was once a recipient of numerous franchisor awards for sales performance, and I was a top 20 performer who owned four territories. In the process of having my business taken away from me, I lost my initial investment, my home, and my family was severely stressed with both great personal consequences. I remember as during these stressful times sitting around the dinner table and there was extreme tension in the air. We were filled with anxiety, dread, and stress, and it took its toll on me and my family. I'm a father of 3 young ones and now undergoing a divorce. I carry an SBA loan for my time as a franchisee, and I'm fortunate that I'm under my current circumstances as an independent small business owner that allow me to continue servicing that loan. But many who are in my cohort of Bright Star franchisees were not so fortunate and have since defaulted. I believe this is no accident. In the case of many franchisors, this seems to be a business model. You recruit franchisees who take out $150,000 to $200,000 loans, set unrealistic minimum sales targets, and then terminate them if they don't meet those targets, then flip their territory and harvest another round of loans ad infinitum. In that model, the small business owners are crushed, taxpayers are on the hook, and the corporate franchisor reports a nice profit on their books. It needs to stop, and franchisees in California need basic protections around termination, like I was terminated. Thank you.
I think you've made your point. Thank you. All right, other witnesses in support, very briefly name, affiliation, and position.
Madam Chairwoman, it's good to see you again. Peter Ligarius, I'm a private practitioner representing franchisees in California for over 30 years. The current bill needs to be amended. This is a good step, and we urge that it be adopted.
Thank you. And if you will stick around in case there are any technical questions, because I know you have some significant expertise in this area. Let us hear briefly from all of the witnesses who are in support. Please, just your name, your affiliation, and obviously your support for the bill.
Scott Wilk, Small Business California, supporting the bill.
Thank you, sir.
Jasper Dillon, 7-Eleven franchisee, board member for the Franchise Owners Association of Greater Los Angeles in Government Affairs. I support the bill.
Thank you, sir.
Nick Tiara, 7-Eleven franchisee, Los Angeles, Santa Barbara, and I support this bill.
Thank you, sir.
Balwinder, 7-Eleven franchisee from Thousand Oaks, support this bill.
Thank you.
Madhusudan Sandhu, franchisee for 7-Eleven, Arco MPM, and Chevron, and I support this bill. Thank you.
Peter Sohota from Sacramento, owning 7-Eleven, supporting this bill.
Thank you.
Jasveer Rana, franchise 7-Eleven, Shell, and Chevron, Sacramento, Roosevelt, and Marysville, supporting this bill.
Thank you.
Lali Gill, this is a franchisee for Subway. Please support the bill.
Thank you.
Roger Kwal from Orange County for 7-Eleven Subway. Please help us.
Thank you.
Jesse Donna, AMPM in Oxnard, Ventura. I support that. Thank you so much.
Thank you.
Al Carlson from Chico, California, Pal Sweet Shop franchisee. Please support the bill.
Thank you, sir.
Matt Matu from Los Angeles, 7-Eleven franchisee. Totally appreciate your support.
Thank you.
Raj Brat, 7-Eleven, and Chevron franchisees. I request you please support the bill.
Thank you, sir.
Rene Bayardo, SEIU, California, also in support.
Thank you.
Arvinder Sidhu from Border Ranch and Small Business franchisee, and I support the bill.
Thank you.
Thank you.
Madam Chair, my name is Ray Dhaliwal. I'm the president for the Greater Bay Area 7-Eleven Franchisee Owners Association, representing several hundred stores, and request your yes on this.
Thank you.
Manjit Purewal, ex-president of the same Greater Bay FOA, 7-Eleven franchisee, Solano County. I support the bill. Thanks.
Thank you, sir.
Paul Diol, I'm with Subway. I'm the board chair for Chico Market, and as a franchisee, I would like your support for this bill.
Thank you.
Aman Rai, franchisee, 7-Eleven, Sacramento, Roseville, support the bill.
Thank you, sir.
Bruce Napel, I'm a lawyer. I've been representing franchisees for 15 years, and I urge you to support this bill.
Thank you very much. Any other witnesses in support? All right, witnesses in opposition. If we could, I'd like to have at least one of the supporters stay. I'm anticipating there might be some questions, and let's make room for the opposition. Great. Thank you. 2 people, 2 minutes each, if you would. Very good. Good afternoon.
Good afternoon. My name is Dean Heyl. I'm with the International Franchisee Association. And after several months of negotiating with CFA, I'm glad to report we will be dropping our opposition to the bill. It was their willingness to compromise on many issues that allowed us to get to that point.
Very good. And as I understand it, the author needs to review those amendments, and which will be taken up on the floor. Is that correct?
My understanding, and again, this got dropped on me, as you know, there's an agreement in principle. Mr. Holden needs to review those, but I don't anticipate any problems, and we would do that on the floor, yes.
And we will certainly be happy to participate in reviewing those as well on your behalfs. Yes, next witness, please.
Thank you, Madam Chair and members. Doug Subers on behalf of the Western States Petroleum Association. We appreciate all the work that's been done. We're still opposed unless amended. We're working on a narrow issue dealing with the gasoline stations. We want to make sure that the federal law that guides the portion of the business of the gasoline dispensers does not come in conflict with the convenience store issue. So we appreciate all the work that's been done and look forward to continuing to work with everyone.
Thank you. And it's my understanding the author is looking at that as well. Very good.
Madam Chair, Chris McKaylee on behalf of the Civil Justice Association of California, and in light of the agreement in principle, we'll be removing our opposition once the amendments come into print. Thank you.
Very good. Thank you. Makes me nervous here that everyone's in agreement, but this is great news. This is great news. All right. Any other witnesses in opposition or in strong neutrality?
Good afternoon, Madam Chair, members of the committee. John Moffat on behalf of Dunkin' Brands, the franchisor for Dunkin' Donuts and Baskin-Robbins. We do appreciate the work that's happened on this agreement in principle. We're reviewing it now. Generally, I think things look pretty good. I would say from our perspective, we still are a little bit concerned about the provision remaining in the bill that allows a terminated franchisee to get reimbursement after that process. As you know, the bill expands those items for which a non-renewed franchisee should be reimbursed if at the end of that agreement a decision is made by the franchisor to not renew. We think the expansion that's in the bill from current law is an appropriate reimbursement. I just think we have an issue and we need to give some thought to allowing that same financial benefit to a franchisee who is terminated under existing law. And so with that, we look forward to continuing to review the amendments and see them when they come in print.
Very good. Thank you. All right. Questions by the members? I know this issue somewhat, and I want to tell you how much I admire the fact that you have actually come very close to an agreement. I don't know, Mr. Dunkin' Donuts, if we're going to get 100% of what you're looking at, but this is certainly everyone's come a long way. And there have been instances, and I'm quite aware of some really egregious lack of sort of parity and overreach. And I think the goal is to try to bring that into some level of balance, and it sounds like you've been working very hard to do that. I want to make sure that those amendments that are taken are going to satisfy both parties. We believe that they will, but I want to keep our committee involved in that process because we are, it will be my recommendation, we vote the bill out today with the understanding those terms are going to be agreed to. I want to make sure that does happen. And again, I think this has been a very interesting experience for everyone, and that appreciate those who came today to speak up, and appreciate some member Wilk that you, after last year, hung in there. And with that, if you'd like to close.
Yeah, thank you, Madam Chair. Again, I think I'd be remiss, again, without acknowledging your leadership on this bill. I believe that we are here today because of your trailblazing last year, so I want to thank you for that.
You've got my vote anyway.
I understand that, but I got in trouble earlier with the GO chair not paying enough deference this morning, so I'm trying to overcompensate now. But fact of the matter is, this is just a small step to kind of balance that relationship between the franchisee and the franchisor. I feel very strongly that when you become a franchisee, you should be a partner with the franchisor, not somebody subjected to their whims. So with that, I respectfully ask for an aye vote.
Thank you very much. Is there a motion? There is a motion. Please call the roll. And the motion is do pass as amended to the Senate floor.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Leno? Monning? Wachowski?
You have 2 out of 2, so we'll keep that roll open, and I anticipate we'll have some success here.
Thank
So
you, Madam
very
Chair
much.
and member.
There you go. Thank you very much.